a legal opinion that is considered as the most eloquent writing in all U.S. Supreme Court decisions. Marshall refused to rule whether or not a writ of mandamus should be issued. Instead, Marshall ruled on the constitutionality of midnight judges being appointed under the legal aegis of the controversial Judicial Act of 1789. Thus, the similarity. The question of the constitutional validity of the Judiciary Act of 1789 is exactly as the same as the question as to the validity of Silt Town Ordinance Number 13, which morphed in Attorney Duran's mind from the vague, obscure, and ambiguous 2008 Town Charter Amendment. Attorney Duran himself said, "I have put meat or flesh on the bones" of the Charter Amendment. I now paraphrase the Honorable Chief Justice John Marshall as follows. If a town ordinance of Silt, Colorado is repugnant to the town's home rule charter, does the ordinance in question bind the mayor and town trustees and oblige the mayor and trustees to give the ordinance effect? To decide that question, it is only necessary to recognize certain fundamental legal principles supposed to have been long and well established. That we, the people of Silt, Colorado, have an unalienable right to select by the election process who will represent our affairs in the day-to-day operations of our town is the basis on which the whole American political fabric has been erected. This principle of consent of the governed is the very foundation of the sovereign political power of we, the people. This original and supreme power comes forth from the will of the people and organizes the Silt town government and assigns to its different departments their respective powers. The people's power may either stop there or establish certain limits not to be transcended by those governmental departments. The government of the United States and the town of Silt, Colorado, is of the latter description. The powers of unelected civil servants are defined and limited, and that those limits may not be mistaken or forgotten, the United States Constitution and the Town Charter of Silt, Colorado have been written. To what purpose are the powers of unelected civil servants limited, and to what purpose are those limitations put to writing if these limits may, at any time, be ignored by those unelected civil servants we the people intend to restrain? It is a proposition too plain to be contested that our home rule charter controls any ordinance repugnant to the charter's protection. Attorney Durant's blatant objections to Mayor Dave Moore's and Trustee Williams' public inquiry into the legality of Ordinance Number 13 subverts the very foundation of all written constitutions, including our Home Rule Charter. Ordinance 13, which is repugnant to the Home Rule Charter and invalid according to all theories and principles of American government, is, according to Attorney Duran's legal advice to the Board of Trustees, completely binding and obligatory upon the day-to-day operations of the town of Silt. Between these two alternatives, there is no middle ground. The Home Rule Charter is either a superior, paramount legal document, unchangeable by ambiguous and vague ballot measures, or our town charter is on a level with town ordinances and is therefore alterable when abdicating trustees and unelected empire-building bureaucrats shall please to alter it. Attorney Duran's unequivocal defense of ordinance number 13 is repugnant to the inalienable rights of the citizens of Silt to protect their town charter, and therefore Attorney Duran's legal opinions and legal positions are not to be trusted and must not stand. The acts and omissions of Attorney Duran regarding these matters is professional misconduct of the highest level and must be investigated by his peers in the legal profession. No one, including Attorney Duran, is above the law. In conclusion, this statement is a notice of intent to file civil action in Colorado's district court seeking injunctions to halt all town ordinances adopted in 2008 and through 2010, and a court ruling on the constitutionality and validity of the 2008 Silt Charter Amendment ballot measure number 2. Now, that's my prepared statement, and I'm going to make another statement now to this body that directed it to Attorney Duran. Gene, as I see it, there's going to be 3 outcomes. The first outcome is this commission, this political body, is going to take a 15-minute break, give you a chance to catch your breath, give them a chance to evaluate what just took place, and then you can come back and think it through and say, do I want to stand up and try to go toe-to-toe with Marbury? Or do I want to admit now publicly on camera to the trustees, the mayor, and the citizens that, one, that ballot measure will not stand constitutional muster. That ballot measure that amended the town charter just won't go there. And 2, because that ballot measure won't stand constitutional muster and is invalid, the subsequent ordinances that I wrote and drafted and almost de facto forced upon the town council are null and void. And 3, you can submit your resignation tonight to the town council, to the town trustees. That's the first option or first way the thing's going to come down. The second,
that's a big option.
Just a second.
The second way it's going to come down, is these politicians are going to say, wait a minute, I was listening to this legal advice over here, and I got some real bad legal advice. Now, this man has the capabilities and the wherewithal and the sophistication to find a lawyer, a competent lawyer, and within a week, he's going to file a civil action in Colorado State District Court. And my political cover is, wait a minute, I listened to the legal advice from town council. I'm running for re-election. Wasn't my fault. That's the second option. And then, of course, they've got to deal with, do we want you to continue as council because, you are incompetent. The third option, the third possibility, is that this town does nothing. And I filed this civil action seeking restraints upon this, seeking temporary restraining orders and injunctions, and asking a state judge to rule on the validity of does this amendment, that ballot measure 2 of 2008, this vague, ambiguous, misleading ballot measure, does it stand constitutional muster? And when that happens, everybody's going to be under the microscope and the front page, and it's going to go on and on and on, and then your legal work isn't going to be under the scrutiny of unsophisticated and naive elected officials. Your legal work is going to be under the scrutiny and the microscope of your legal peers, a judge.
I invite that.
Okay.
I invite
Okay.
that.
Just a minute, go ahead.
Mr. Mayor, can you please clarify that?
Just a second.
Mr. Mayor,
Just a
he
second.
was able to speak his piece,
No.
and now he's extended it.
He's not finished.
We have an agenda that is before the board tonight,
Maybe
Mr. Mayor.
30 minutes,
we-
Mr. Mayor.
And secondly, can you please advise Mr. McWilliams that I did not draft that matter that he's so critical of? It was drafted by prior counsel. Because if he's going to defame me, he better get his facts straight. Otherwise,
No,
it's not an
It's in
alien.
written-
His facts are not
Hold it,
straight.
just a second.
The
Hold
entire
it.
diatribe.
Just a second. I will point on each one. Number one, we cannot enter into a personnel matter in a public meeting.
We already
You
have.
allowed
hold
that.
it. He has got now correct me if I'm wrong, he's got the freedom of speech. He can come in and express his displeasure.
Mr. Mayor, time and time again, you have indicated that you run these meetings. It's within your discretion to make that decision whether to allow him to bring up personnel matters. Nobody stopped him.
I
I would
made my
also like-
statement.